And all right, it's all you, Mac.
Thank you. And just although this part's going to be a bunch of talking head, I do encourage people to sort of post in the chat questions that they have. Those that we can get to in the space that we've got in between the two pieces, we will. And I think if something doesn't get answered and it's in the chat, we can follow up with it afterwards. So just wanted to start off talking about what is a grievance procedure in public housing. And so the main thing to think about this is it's a dispute that an individual has with the housing authority, and it's a way to resolve that dispute without having to go to court. And there are two main ways in which this could happen. One would be the housing authorities taking some kind of action against you, and you're wanting to dispute that. So an example might be you wanted to add somebody to your household. The housing authority said, no, you can't add that person to your household. That's certainly something you could file a grievance about. Or the other one is the housing authority isn't taking action or is taking action in a bad way on something that you have a problem with. Good example there is repairs. And we're going to be talking a bunch more about repairs because that's the example we've chosen to use for the role play. But there could be other things where the housing authority isn't getting around to something that they should be addressing. Now, in both state and federal public housing, grievance rights exist. We're going to be talking a little bit later on about how they may be different. But they both have this concept of both an informal settlement conference, which is sometimes referred to as a private conference, and then the grievance hearing. And those two steps are both very important. The informal settlement conference gives you an opportunity to sit down with staff from the housing authority to talk things out, to see if there is a way to resolve things without having a formal hearing decision. And oftentimes it can be quite productive. But we'll be talking a little bit later on about like when you might want to use that and talk a lot, and when you may want to use it to try to get information, but not talk a lot, because there can be different cases and different ways to use the informal settlement conference. And then we're going to be talking about the actual hearing, how to prepare for the hearing, how best to present your case for the hearing, and so forth. So um, the one key question is, how do you find out what the grievance procedure is in your development? And I know the answers to that are going to differ all over the place. There's going to be a mess. Some of the things Sarah was talking about earlier about trying to straighten out those messes with different housing authorities is important. But key ways to do it is, one, it might be an attachment to your lease. So look at your lease, see if it's there, because it might be right there with your lease. Second thing would be is your housing authority may have a website, should have a website, and you should check the website. And if you're in state public housing, they're actually required to post the grievance procedure on the website. Then another way is to go to the housing authority's main office, because both federal and state law say they're supposed to post that grievance procedure at that main office. You could also just ask for them to provide it to you. So, if all those other ways aren't working, or for example, you don't have an easy way to get online and it's a real hardship to get downtown, you might say, hey, I need a copy of this grievance procedure. Can you get it to me? One thing that's important though is to figure out that you've got the right one and it's updated, because some housing authorities are really messy about their grievance procedures, and they might give you one that's not the most up-to-date one. And so it's usually a best practice, if you're working with the housing authority doing advocacy for other residents, is to try to get the housing authority each time it changes it to say updated as of X date. And that way, if you're looking at something that was done in 2021, you can be relatively sure, okay, that's probably current. Whereas if you're looking at one that says like 1987, it's probably not up to date. And you may want to ask some more questions. And one thing to also know is that if they decide to change the grievance procedure, they're supposed to work with the residents and the resident organization about any of that. So they're supposed to send you what they're thinking of changing, give you the opportunity to comment on that, and then when they're all done, say, here's what we finally decided to do. Based on your comments, we didn't do X, Y, or Z, and then we did do this other thing. And they should share the final result of that. But if the housing authority just tries to impose a change in the grievance procedure without going through the residents, that's wrong. They're supposed to give you that chance first to weigh in. Now, one question that people have is, do different tenants have different grievance procedures? And unfortunately, this can be true, and it can get a little confusing. So the requirements that the state has and the feds have for state and federal public housing are a little different. I'll just give you an example. State public housing, the state law does not say that housing authorities have to give you a grievance hearing in a non-payment eviction. Whereas for the feds, you do have to provide the opportunity for a grievance hearing in a non-payment eviction. There are also some exceptions that state law has for different types of serious cause evictions. And those are slightly different under state and federal law. So you will see some differences depending on whether or not you're in state or federal housing. So make sure when you get a copy of the grievance procedure, it's the right one. Some housing authorities are good and use a consolidated grievance procedure. They've gotten OKs from HUD and the Department of Housing and Livable Communities to say, hey, this is the one we're going to use for everybody, and they've blessed it. But some other ones have different ones for their state side and their federal side. Just make sure they're giving you the one that's relevant to the kind of housing you live in. And one other thing that we're seeing increasingly, and I know this relates to the work that Mass Union's doing statewide right now, is there's a big push on to get redevelopment of public housing and to get new money into developments, particularly where state or federal money hasn't been enough. And that may result in switching things to like Section 8 subsidies or MRVP subsidies or using tax credits. And that's what's sometimes referred to as mixed finance public housing. And if they do that, then they probably are going to have a different grievance procedure that's a requirement for whoever is going to be the owner of that site. But it still should have the same basic protections. That is, you should still have the informal settlement stage. You should still have the opportunity for a grievance hearing. And most things are going to be grievable. There might be some things that are disputed in different ways, like if you have a Section 8 subsidy through the housing authority, you might have to go to the Section 8 people to deal with rent disputes you have. Whereas if the issue is the owner at that site is not maintaining the place, you'd use the grievance procedure with that owner. I'm not going to go in great detail about this, but just be aware that this is stuff to flag. Things will be different. And your local legal services offices in Mass Union would be happy to work with you if those issues come up. So one question that people have is, when am I supposed to be told about my grievance rights? So an important thing there is, if they're taking action against you, they're supposed to put in the notice that's taking the action against you what your grievance rights are and the deadlines you have to ask for certain things. So if, let's say, they have rejected a request you had to add somebody to your household, the notice should say, if you disagree with this, you have the right to have an informal settlement conference with us. And if it's not resolved, then you have the right to request a grievance hearing. And those notices should also advise you of any deadlines that you have to do that and who you need to get that request to. Because sometimes it says there are specific people that you need to get it to because maybe not everybody at the housing authority deals with X, Y, or Z issue. If the notice doesn't tell you, and if they're taking action against you and the notice doesn't tell you about grievance rights, that's probably wrong. It's probably a mistake, and you probably can get that fixed and force them to go back and start over again and give you the notice about your grievance rights. But it is also important for you, if you get any of those notices, to make sure you respond right away in whatever way they tell you to, because otherwise it might be that you got a piece of mail, you just left it on the pile. I do that. And then like you go back a while later and you look at that piece of mail, you say, whoops, oh, I didn't realize that this was something where I needed to get my grievance request in within 10 days. And now more than 10 days has gone by. Um, there may be times that you would be able to convince them that you had some good reason for being late, like maybe somebody was hospitalized and couldn't respond to something right away. But it's just really important to any notice you get from the housing authority, look for that stuff and make sure you do it. If it's the kind of thing where you're the one initiating the grievance because they've just been sitting on stuff like a repair issue, then you just have to act within a reasonable time period. So you probably couldn't grieve something that happened 3 years ago. But let's say you're still having a leak in your apartment. The fact that you first complained about the leak, over a month ago, probably isn't a problem if you're still having the leak. So that one's just more being reasonable on how you respond. So a question that people pose to us all the time is about, can the housing authority try to take action against me because I was filing a grievance, or I'm worried, I'm nervous, I'm anxious, I don't want to rock the boat. I don't want to sort of upset them in some way that they weren't upset otherwise. Well, grievances are like other kinds of complaints that you have. Massachusetts law usually protects you against action being taken against you in retaliation for a complaint you've made. And grievances are one of the types of complaints that you can make, just like if a tenant called their local Board of Health and the Board of Health came out and cited the landlord is not supposed to take action then in response to the Board of Health report to jack up your rent or take an eviction action against you or things like that. That's unlawful. On the other hand, agreements won't necessarily protect you against something else that was already going on. So let's say that if you were already behind on your rent, and you were then going to file a grievance, that grievance wouldn't necessarily protect you against the housing authority taking action against you for being behind on your rent. So as I usually advise tenants who have Board of Health reports, I say, straighten out the rent issue first, try to get that's all squared away so they don't have that as an excuse, and then get in your Board of Health report and your other things, and then you are protected at that point. And once you've filed a grievance, they shouldn't then move things forward until they've finalized the grievance. So let's say that they were alleging that you were bothering a neighbor, and that's the nature of the allegations that they've made. You've said, that's not true, and here's my grievance about that issue. Then you're entitled to work that all the way through the process, through the informal settlement conference and through the grievance hearing, before they should be taking any further action against you on that matter. That doesn't mean that the housing authority can't take other action, like if that was the issue, you still have to pay your rent, for example. And so if then you weren't paying your rent, they could, send you a separate notice saying, and because you're behind on your rent, we're taking action on that. But they can't take any action against you for the complaint that you've made or for the thing that you are grieving until it finally gets played out the full way through the grievance procedure. Let me talk a little bit about the informal settlement conference, because we mentioned that earlier. And the informal settlement conference is really important to work out a lot of cases. So it may very well be the housing authority just doesn't have the right information about what's going on. Or it could very well be that the main reason they started to take action was they wanted to prompt you to do something. So it could be, for example, the housing authority doesn't have complete records on your recertification. And so they send you a notice about to start the process. You ask for the settlement conference, and at the settlement conference, you bring them in X, Y, or Z. Or you say, hey, wait a minute, look at my file here. Here's all the things I already turned in. I think I was trying to respond to you. And you can get into a conversation to try to work things out. You can also sort of explain circumstances of yours, like, oh yeah, there was I did have a little bit of a dispute with my neighbor and people's voices were raised, but that's because we had this person come in who was a former household member, and I told him he had to leave. And we've got court protection now, and that's not likely to be a problem again. And in addition, I understand I've got some protections against domestic violence, and that you're supposed to protect me as a victim of domestic violence. That's an example. Or yes, I'm a little bit behind on my rent, but here's my plan for how I'm going to catch up. And should be thinking about, are there ways you can resolve the problem short of things going further? So many times people might work out a management agreement with management that might say, okay, if you keep this repayment plan, pay your current rent, pay a certain amount each month toward the back rent until you get to zero balance, we're not going to take the case any further. Or as to that complaint your neighbor had, we hear what you're saying. You've agreed that so-and-so is not going to be there for a bit, whatever. Or, your complaint, here's the things you're asking the housing authority to do, and they say yes. But it's really important to be careful about the conversation because, for example, you want to stay cool, calm, and collected. Sometimes it's a good idea to have somebody else with you, like a friend or a neighbor or a family member, because you might get off track or forget what somebody else said. And so having somebody else there to be your witness, having somebody else there to sort of help you stay focused in case, they're doing things that would get you upset, which certainly can happen. And also anything that you say at the private conference can be used against you. So sometimes in some of these more serious cases, you may not want to volunteer information to the housing authority because they can use that information. So you need to be careful. You can use the private conference as an opportunity to just find out, well, what do you have on me? Like, what was the basis for this? I really can't tell by this notice that I got from you. But then if you don't say anything, it's unlikely you're going to resolve it at the private conference. So sometimes people are using the private conference just as a mechanism to get more information and to sort of delay things a bit until they can get other help. But there are other times when people are using the private conference to truly try to um, see if you can resolve the issue at that point. So you'll just have to play that a little bit by ear. But again, having somebody else there with you, and that could include somebody from your tenant organization if you're comfortable with that. It might in fact include somebody from Mass Union. It might include somebody from legal services or a group like the Tenant Advocacy Project at Harvard Law School if you're in their catchment area. That can work. So let's talk a little bit about, let's say you went to the informal conference, the settlement conference, you couldn't work it out. And so now you've filed for the grievance hearing, or they've automatically scheduled it for the grievance hearing. Some housing authorities will automatically schedule it after that first stage. Others will say you have to affirmatively write something else. So you have to check out what the piece of paper says. But let's assume that you've asked for the further hearing, and the housing authority is then scheduling the hearing. So there are different kinds of hearings. You could have a hearing panel, you could have a hearing officer, and different housing authorities have different ways of doing that. The tenant organization should be involved in helping to select the grievance panel or hearing officer. So that's an important role your group can have. So it's important when you're preparing your case to making your case that you need to be clear about what you think the housing authority did was wrong, why you think it was wrong, and what you want them to do. So when you put that in writing, you might want to review that request in writing with others before you ship it out, so that it's clear. Because sometimes, the grievance can be a little bit murky, and then the hearing officer or the housing authority really isn't clear about what you want. You want to document anything that could be relevant to your case and have that available to you at the grievance hearing. This could include letters or emails to the housing authority staff showing you alerted them to your issues or problems, and you've cooperated in providing information. You want to have any pictures or reports that back up your story about what's happened. You want to present things in a clear narrative so that people don't get confused. And I know sometimes that can get really complicated, particularly if the housing authority starts piping in and they start like going back 3 years, and you say, wait a minute, that's not what we're talking about here. We really want to focus in on what's going on right now in my apartment. But that may all, again, be a reason to have somebody else there with you to help you sort of stay on track on that. And you want to prepare your presentation in advance and stay calm and focused. One thing I find sometimes helpful, and it's something I do I did as a lawyer in court, but I think anybody can do it for themselves, is have a little checklist. So, make sure that there are X number of key points you want to make sure you've gotten in during your hearing, that you haven't forgotten. So having your checklist and checking them off is one way to do that. And then it may be helpful for you to rehearse. So you might want to have a friend or several friends play the roles like we're going to do in the role play today, so that you've got some chance to sort of think about, okay, how would that go? Or how do I need to do that a little bit differently? You want to think about the order in which you're going to present things. And sometimes that gets confusing because you may be thinking, oh, they're going to start with me. Or you may be thinking, oh, they're going to start with the housing authority. And it turns out it's different. It's the other way around. So you just have to be, flexible enough to sort of roll with it. That if they change the order of it, so it's the other person that's starting first, you're then able to say, okay, fine, I can pick up from there. If at any point you're confused about what's going on, you should say, excuse me, just a moment, I didn't quite understand that. or, particularly, I didn't hear that. I didn't understand what you were saying. Sometimes people talk in jargon. They might use terms that are common to the housing authority or HLC, but aren't common to the normal human being. And so you want to go back and say, okay, what did you mean by that? And then have them break it down in a way that you get it. You want to have enough detail that you get everything in, but don't be so long-winded that you lose people. So usually think about, okay, how much time is this going to take to get this done? And I just want to make sure I get that done within the time period. And speaking of which, I think I'm at the end of my time period. So I'm going to stop right here in case there are questions. I may have in fact gone over even a little bit. Sorry.
All good. Thanks very much, Mac. A lot of dense information here. And yeah, we have a lot of really good questions in the chat. So I'm actually gonna summarize one from that's similar from Jada and then from Chris. If the housing authority replaces stoves with toaster ovens or hot plates, is that a grievable situation?
I think it would be. So I think it would depend a lot about what the circumstances were. So let's assume that the reason they did a replacement was that there were fires that happened in the unit, and there might have been an issue with a tenant, not minding a stove, and because that fire alarms went off. And so, for example, I've seen cases where housing authorities have then replaced it with like a microwave, where the thing is actually going to stop at a particular point, as opposed to keep going on and causing a fire. But I think, generally speaking, the answer is yes, that's definitely grievable, because that's a sanitary code issue. They provided an appliance. They have an obligation to continue to provide that appliance. There might be some temporary gap measure that they're taking while they're fixing an appliance, but I don't think they could permanently substitute something for something else, absent some kind of good cause like a reasonable accommodation.
Mm-hmm. Okay, so when in doubt, you can file the grievance and kind of see what happens, right?
Yep.
Yeah.
Yep.
Okay, so because I know some folks are kind of in like a gray area where it's temporary, but then these things go on and on and on. So it certainly doesn't help to file a grievance, hurt to file a grievance.
Right.
And let us know at Mass Union about these situations too.